Thank you for being here. I'm sorry I'm a little bit late, so let's get started. I call this hearing to order. At a time when small contractors are disappearing from our industrial base, we've lost over 100,000 since 2013, the administration continues to place additional burdens on those that would like to sell their goods and services to the federal government. We should be working to expand the universe of contractors, not shrink it. However, I feel the administration's actions will further reduce the number of small contractors that are participating in the federal marketplace. Since 2009, President Obama has issued 13 executive orders that relate to government contracting, which have resulted in 16 new regulations so far, and there are likely to be more to come. While some of these mandates may be well-intentioned, they also have cost, and too often costs significantly outweigh the actual positive effects. In that fact, it is estimated that compliance with government-unique regulations costs almost 30 cents of every contract dollar. Today, we're going to talk about the Executive Order 13,673, which the administration has titled Fair Pay and Safe Workplaces. As a former small business owner, I support the idea of fair pay and safe workplaces. I'm sure we all do. Companies with labor law violations that affect the performance of contracts should be suspended or debarred. However, the executive order and the resulting proposed legislation and guidance so far go way beyond that. Instead, it seems to punish companies for unproven allegations. The Department of Labor and Federal Acquisition Regulatory Council have the primary responsibility for implementing Executive Order 13673. So I'm glad that we have key officials from both agencies here today. I hope they listen to the small businesses that are testifying and truly consider the significant negative consequences associated with their proposal. There are valid concerns that implementation of this executive order will result in potentially innocent small businesses effectively being blacklisted from participating in government contracting. I do not believe that the Obama administration would intend this to be the result. But as drafted, implementation of Executive Order 13673 is likely to yield this result. So from my standpoint, this seems to be an executive order in search of a problem. But I'm here to listen today to those who would be affected and those that will be implementing this executive order to determine if there is anything that the administration could do to make it more workable. With that, I yield to Chairman Hardy for his opening remarks. Chairman?
Thank you, Chairman Hanna. I'm pleased that our subcommittee is holding this hearing to examine the impact of Executive Order 136073 on small businesses. In my opinion, this executive order is just another example of the executive overreach that has become the hallmark of the Obama administration. And it could have a devastating effect on small business and government contractors. I agree that the companies who are considered bad actors in their field should not be rewarded with federal contracts, but there's already a process that allows federal government to weed out these bad actors. Instead of using the existing process, the Obama administration is going to impose significant new burdens on all federal contractors, even though it says that the vast majority of federal contractors play by the rules. Small businesses do not need to be forced to settle unproven claims. They should not be forced to disclose commercially sensitive information to their competitors. And they also should not be forced to report information that the federal government already has. Most importantly, they should not be blacklisted from participating in federal contracting based on the accusations that they were ultimately being proven innocent for the past labor law violations in which they have already paid fines or otherwise corrected. I'm particularly concerned that this executive order will lead to fewer small businesses selling goods and services to the federal government. We need a healthy industrial base with many small businesses working to provide the government with the innovative goods and cost-effective services. When fewer small businesses compete for federal contracts, the outcome will be less innovation and higher costs to the taxpayer. This is not good for the United States. I cannot help but think the additional mandates that have been piled onto the government contractors by this Obama administration has led some small businesses to leave the marketplace and discourage others from entering it. After all, increasing the cost and complexity of government contracting makes it more difficult for small businesses to sell goods and services to the federal government. I'd like to thank the witnesses for appearing before the subcommittee today, and I look forward to hearing your concerns of the small government contractors, and I look forward to the discussion, discussing their concerns with the representatives from the Department of Labor and the Federal Acquisition Regulatory Council. And with that, I yield back, Mr. Chairman.
Thank you. Mr. Takai, the ranking member.
Thank you, Mr. Chairman. Good morning and aloha. Thank you, Mr. Chairman, for holding this important hearing. Small business participation in the federal marketplaces has always been a priority for this committee and Congress. When entrepreneurs are able to sell their goods and services to federal agencies, there is a win-win situation. Taxpayers receive more bang for the buck with the delivery of quality products and services being supplied by the government. Meanwhile, many small firms are able to grow, confident that they have a client and a partner that will provide them with a steady stream of reliable work. The federal marketplace continues to constitute a significant portion of the U.S. economy, with government spending at $447.6 billion in fiscal year 2014. In the past, Congress has used this significant financial might to help drive forward a number of policy goals. We've passed legislation, for instance, aimed at ensuring small businesses get a fair shot at these projects. Likewise, this committee has worked in a bipartisan manner to help women and minority-owned businesses navigate the procurement process. The fact of the matter is, as a large customer, the federal government has the ability to use its buying power to advance priorities important to our nation as a whole. It is in that context that we must view the President's most recent executive order, which is designed to ensure that firms that contract with the federal government understand and comply with laws. We should be clear, of the businesses that perform work for the government, the overwhelming majority comply with labor and safety laws and do right by their employees while remaining providing excellent goods and services at competitive prices. That said, this committee has heard a number of bad actors who have skirted the law and continue to receive federal contract work. Not only is this bad for workers, but it puts honest firms that abide by these rules at a disadvantage. Simply put, federal agencies should not be rewarding companies with a poor labor and safety record with additional opportunities at taxpayer expense. Executive Order 13673 is an attempt to address this challenge by requiring companies to disclose previous labor and safety law violations from the past 3 years. Even if a contractor has such violations on record, firms would only be denied contracts in the most egregious of instances. While this is a reasonable goal, all of us want to see safe workplaces. We must monitor carefully the details of how it is implemented. There remains a number of thorny technical questions about how this new proposal will impact small businesses. For instance, many small businesses act as subcontractors to larger companies that bid on federal work. In most cases, the work they do fulfills the majority of the scope of work under the contract. Under this new order, prime contractors will be required to obtain labor law violation certifications from their subs. There are reasonable concerns that prime contractors may avoid doing work with certain subs altogether in the event of any previous problems with labor laws. This raises issues about whether subcontractors should simply certify directly at the agency level. These and other issues will need to be addressed as this committee examines this executive order. As always, it will be our challenge to balance small businesses' very real concerns against the legitimate needs to protect the public and, in this case, ensure federal dollars are spent in a way that does not harm workers. I look forward to hearing the witnesses' perspective on these important topics, and I yield back. Thank you, Mr. Chairman.
Thank you. Oh, Ranking Member Adams?
Thank you, Mr. Chairman. Each year, the federal government spends over $400 billion in taxpayer dollars to provide private companies for goods and services. And while these funds boost the economy and allow firms to hire more employees, we've seen instances in which these same businesses violate safety and wage laws to increase their profits. According to one report, almost half of the total initial penalty dollars assessed for occupational safety and health administration violations in 2012 were against companies holding federal contracts. Unfortunately, the safety and labor violations do not stop there. Multiple employees at some facilities have sustained injuries, and some have even lost their lives. However, rarely were the businesses where these incidents occurred debarred or suspended from the federal marketplace as a result of their unsafe working environments. Labor laws are crucial to a healthy economy. When workers receive their proper wages, they participate in the economy as consumers. Additionally, providing a safe working environment in which injuries are unlikely allows employees to continue working and employers to increase their productivity. Therefore, to ensure that contractors are adhering to these important laws, President Obama issued the Fair Pay and Safe Workplaces Executive Order last year. The order is intended to increase efficiency and cost savings in the work performed by contractors by ensuring they understand and comply with labor laws. Under the proposed guidance issued to implement the order, contractors who are bidding on contracts valued at over $500,000 will have to disclose their labor law violations that have occurred within the past 3 years. Contracting officers, with the help of Labor Compliance Advisor, will then use this information to help determine whether or not a business is responsible. The regulations fit into the existing procurement process. The contracting officer will just have access to additional information regarding contractors' labor history. Furthermore, the order also provides employees protections to ensure that they receive accurate wages and have the opportunity to litigate certain claims in a court rather than by arbitration. However, as we hear today, there is some concern that the executive order will be overly burdensome on small businesses. Small businesses provide quality goods and services at affordable prices, meaning a better deal for the government and the taxpayer. Yet they have smaller margins, and new regulations can be harder for them to absorb. With small businesses creating over 2/3 of new jobs, our economy needs both small businesses and healthy and safe employees to properly operate. Therefore, in moving forward with the implementation of this executive order, it's important that we find a balance in which small businesses are not overly burdened by complying with the guidelines while still ensuring that contractors who habitually put their employees in harm's way are removed from the contracting process until they've shown progress in correcting their labor law compliance. And with that, Mr. Chairman, I'd like to thank the witnesses for testifying today, and I yield back.
Thank you. If committee members have an opening statement prepared, I ask that they submit it for the record. Just for information, you probably already know this, you have 5 minutes. When the light goes yellow, you have 1, but we'll be lenient. So with that, our first witness is the Honorable Angela Stiles, who currently serves as chair and partner of Crowell and Mourning and co-chair of the firm's Government Contracts Group in Washington, D.C. From 2001 to 2003, Ms. Stiles served as the administrator of the Office of Federal Procurement Policy at the Office of Management and Budget. Ms. Stiles, in the interest of time, you may begin.
Thank you. Thank you, Chairman Hanna, Chairman Hardy, Congressman Takai, Congresswoman Adams, and members of the subcommittees. I appreciate the opportunity to appear before you today As co-chair of Kroll and Mooring's Government Contracts Group and as former administrator for federal procurement policy at the Office of Management and Budget, I have worked closely with small business contractors throughout my professional career. I am deeply concerned that the executive order will undermine the government's longstanding policy of maximizing contract opportunities for small businesses. If the EO is aimed only at a small number of bad actors, then surely there is a more efficient way to accomplish this goal than imposing requirements that will lead to procurement delays, the blacklisting of ethical companies, and reduced competition in the federal marketplace. My written testimony today highlights the following 5 principal concerns: potentially severe unintended consequences for small businesses, the high compliance costs that will deter small businesses from participating in the federal marketplace, the diversion of federal employees from assisting and growing our small businesses to collecting data, monitoring compliance, monitoring enforcement of federal and state labor laws with a high risk of de facto debarment of companies, a flawed Regulatory Flexibility Act analysis, and really failure to give even the most basic rationale for the necessity of this rule. For a more in-depth analysis of many portions of this rule, I refer you to the official comments submitted by the National Association of Manufacturers. They were a client of Kroll and Moorings, and I attached it to my written testimony. We really worked for months and months with the National Association of Manufacturers and many companies in industry to really fully understand this rule and the potential impacts of the rule. But even then, you don't consider everything. I was sitting last night thinking about the rule itself, and really the hypocrisy of the situation is quite striking to me. While on the one hand, you have a relatively new OFPP administrator that is issuing commendable and forward-thinking memorandum on efficiency and performance and improvements and cost savings for taxpayers, and on the other hand, you have this administration issuing the most bureaucratic, far-reaching, extensive EO and proposed rule that I've seen in my entire career in federal procurement. You can't have it both ways. You can't have it both ways. You can't be efficient while at the same time issuing something that is such a bureaucratic morass for companies, but really particularly for small businesses. I think for me, a significant and wholly unanswered question is why the federal government is creating this burdensome process in the first place. As Chairman Hanna said, this is an EO in search of a problem. Each and every labor law identified in the EO has its own separate penalties for companies who violate the respective laws. And unlike the EO, those labor laws and associated penalties were created by Congress rather than mandated by the executive branch. The federal procurement system also has adequate remedies to prevent companies with unsatisfactory labor records from being awarded federal contracts. Specifically, suspension and debarment officials within every federal agency have broad discretion to exclude companies from federal contracting based upon evidence of any cause, this is quote, any cause so serious or compelling in nature that it affects the present responsibility of a government contractor. To the extent that a contractor's compliance record impacts its present responsibility, FAR subpart 9.4 sets forth proper channels for suspension and debarment proceedings. With established and effective systems in place, it makes no sense to create a new bureaucracy to review these contracts on a contract-by-contract basis with the possibility of astoundingly inconsistent decisions by different agencies and different contracting officers. Given the scope and complexity, this EO will be impractical, if not impossible, to implement. The substantial costs of compliance imposed on federal contractors will likely lead to higher procurement costs, and I think drive many small businesses out of the federal marketplace altogether. These costs will be borne disproportionately by companies who can least afford them, our small businesses. This is an entirely unacceptable outcome. The goals of the EGO are targeting contractors with the most egregious violations, but it could be accomplished through the enforcement of existing labor laws and our existing suspension and debarment system. This concludes my prepared remarks, but I'm happy to answer any questions.
Thank you. Our next witness, Theron Peacock, the senior principal and president of Woods and Peacock Engineering Consultants, a service-disabled veteran-owned small business with 16 employees located in Alexandria, Virginia. Mr. Peacock has 38 years of experience and co-founder his present business after 22 years at 3 other firms. He is here testifying on behalf of the American Council of Engineering Companies. Mr. Peacock?
Thank you, Mr. Hanna. Subcommittee Chairman Hanna, Hardy, Ranking Members Takai and Adams, and members of the committee. I appreciate the opportunity to testify before you today about the issues surrounding the Fair Pay and Safe Workplace Executive Order. My name is Theron Peacock. I'm a senior principal and the president of Woods Peacock Engineering Consultants located in Alexandria, Virginia, and we have 16 employees. Woods Peacock is a service-disabled veteran-owned small business that focuses on service to a very broad range of federal agencies. My firm is an active member of the American Council of Engineering Companies, the voice of America's engineering industry. ACEC's over 5,000 member firms represent hundreds of thousands of engineers and other specialists throughout the country. They are engaged in a wide range of engineering works that propel the nation's economy and enhance and safeguard America's quality of life. Almost 85% of our firms are small businesses. First, ACEC appreciates the Labor Department and the FAR Council's efforts to improve labor compliance practices with federal contracts. However, as Chairman Shabbat, Shafis, and Klein have noted, this guidance is fixing a problem that does not exist. The Council is concerned that the guidance will make compliance so difficult that it will drive a significant amount of private industry, both large and particularly small business, from the federal market. There are 3 broad issues with the guidance that the Department of Labor and the FAR Council released this past May. First, the reporting is burdensome and duplicative. Under the guidance, there are 14 federal laws and executive orders that implicate the law. Are you aware that much of the reporting data that is requested is already reported to a variety of federal agencies? For example, annual compliance reports are required for EEOC, OSHA, and the Rehabilitation Act, and Davis-Bacon requires weekly reporting. Additionally, all federal contractors are required to file annual reports in SAM. Why add another report when the data has already been received? Let me just give you an example. As a subconsultant, we have contracts with over 30 prime AEs. If we need to submit these reports to all 30 primes, who in turn submit the information to the government, you will be getting the very same information multiple times and putting it in the same database. When you consider that each prime needs to have multiple firms under their contracts, this accumulates into a very significant duplication of record that would do nothing more than create confusion. Second, these regulations will significantly complicate the relationship between primes and subcontractors and will likely result in the development of a blacklist for subcontractors, significantly reducing the number that will qualify to do federal work. Under the guidance, at the time of execution, contractors must require subcontractors to disclose any administrative merit determinations or other complaints within the preceding 3 years. This will force the contractors to bar any subcontractor that is stuck in any judicial process. In engineering, roughly 50% of prime engineering work is subcontracted. Primes and subcontractors switch positions frequently. By requiring primes and subs to share confidential business information, they are sharing information that can damage your ability to compete against each other in the future. Third, there are due process implications with these regulations. Under the guidance, claims that have not been decided or even heard by a judge will obligate the firm to make a report. This will allow for claims that will have not had the benefit of a third-party hearing of the dispute to potentially place the firm in positions to lose their business. It also places the contracting officer in an untenable position. Under the guidance, the labor advisor has 3 days to decide on the outcome of a report. If the labor advisor does not submit a report, then the contracting officer will have to make the decision regarding a firm's labor compliance. The contracting officer will become the judge in a complaint, and they aren't qualified to do that. Given the risk-adverse nature of contracting, this requirement will force the contracting officer to disqualify the firm or subcontractor so that they aren't subject to the risk of censure. ACEC asked the committee to work with Labor and the FAR Council on redrafting the rule to make sure that construction services can succeed in the federal marketplace. These regulations have the potential to unfairly prohibit my firm and many of ACEC's member firms from participating in these opportunities. Thank you for the opportunity to participate in today's hearing, and I'd be happy to respond to any questions from the committee members.
Thank you. Our third witness is Ms. Debbie Norris, who served as Vice President of Human Resources for Merrick & Company, a federal contractor based in Greenwood Village, Colorado, which is located just outside of Denver. Ms. Norris, you may begin.
Chairman Hanna and Hardy, ranking members Adams and Takai, and distinguished members of the subcommittees, my name is Debbie Norris, and I am Vice President of Human Resources at Merrick & Company, a small business federal contractor located in Colorado. I appear before you today on behalf of the Society for Human Resource Management, or SHRM. Thank you for the opportunity to testify today on my experience as a representative of small business competing for and managing federal contracts. Mr. Chairman, first, let me make clear that the President's goal of providing fair pay and a safe workplace is a shared goal. After all, who wouldn't be for that? In fact, I work to provide a safe workplace and to help make Merrick an employer of choice, not just because it is the right thing to do, but because it provides us a competitive advantage in our industry. Unfortunately, this order as written is unworkable and should be withdrawn. In fiscal year 2014, my company, Merrick, managed 329 federal contracts, some of which we were prime and some of which we were sub, for the Department of Defense, Department of Energy, NNSA, National Science Foundation, among many others. We have been recognized as a best company to work for in Colorado on 5 different occasions. Our internship program has been recognized as a best practice in the Denver metro area. And I mention these awards because despite the fact that my company invests significant time and resources on compliance and creating a sought-after work environment, we believe the FAR Council regulations and the DOL guidance to implement the Fair Pay and Safe Workplace Executive Order will have a significant and negative impact on our ability to maintain current contracts, compete for new ones, as well as attract employees. In my testimony today, I will address some of the key concerns small businesses have with this proposal. First, I am really concerned about requirements to report non-final agency actions. In my experience, it is not uncommon for companies to undergo agency investigations and even be issued a notice of a violation that turns out to be unfounded. If non-final agency actions are considered, companies like mine could lose a contract as a result of cases or investigations that are not yet final or eventually dismissed. I would like to offer one example. As a federal contractor, Merrick is audited by the OFCCP on a periodic basis. Our current audit started in September 2014, and we still have not received a determination from the OFCCP. Not very timely. We are concerned that unresolved actions like this will have a negative impact on our ability to compete for future federal contracts. In addition, federal contractors will feel pressured to settle a claim or enter into a labor compliance agreement with a federal agency, even if they feel they have done nothing wrong. Second, I am very concerned by the DOL's proposal to create powerful new positions called Agency Labor Compliance Advisors. These advisors insert themselves into an existing relationship between contractors and contracting officers to provide guidance on assessing the seriousness of reported violations. Due to the ambiguity of definitions in the guidance, inappropriately broad discretion is given to these advisors. Third, I am also concerned about the record-keeping and ongoing reporting burdens placed on small businesses. Collecting and reporting on information deemed a labor violation under 14 different federal laws and unnamed number of state laws will not be an easy task. Doing so will require contractors to create a company-wide centralized electronic record of federal and eventually state violations over the past 3 years. Merrick has 18 different offices in 8 states, as well as offices in Mexico and Canada. This proposal places an additional burden at headquarters of ensuring that each office is regularly and accurately reporting this information to us. When staff time is directed to responding to compliance requirements, it takes away from the HR department's focus on the needs of our employees and meeting our business and clients' objectives. Contractors will likely handle this situation in one of two ways. They either will try to make do with existing staff, which may result in a failure to meet the contracting obligations, or they will hire additional staff, which will end up costing the government more. And a third reason is they may actually just exit the federal market. Fourth, this information is already collected. As a contractor, we already report this information to the government, and they should use the data it already collects. In closing, SHRM believes that the proposals create an unworkable system that will cause harm to the federal contracting process and impose requirements on contractors and subcontractors that are impractical and hugely expensive, especially for smaller business. Mr. Chairman, thank you again for allowing me to share SHRM's views on the FAR Council and DOL proposals. I welcome your questions.
Thank you very much. I now yield to Ranking Member Adams for the introduction of our final witness.
Thank you, Mr. Chair. It's my pleasure to introduce Mr. William Albanese. Mr. Albanese is the General Manager of A&A Industrial Piping in Fairfield, New Jersey, a business with over 20 years of experience. Mr. Albanese is testifying today on behalf of the Campaign for Quality Construction. The campaign represents 6 specialty construction employer associations that have over 20,000 members, the vast majority of which are small businesses. These members perform construction projects in the public and private construction market as prime contractors and subcontractors. Welcome, Mr. Albanese.
Thank you. Good morning, Chairman Hanna, Chairman Hardy, ranking members. I thought I was going to ask you a couple minutes. Good morning, Chairman Hanna, Hardy, ranking members Takai and Adams. Thank you for the opportunity to testify in support of the goals of President Obama's Fair Pay and Safe Workplaces Executive Order. I would like to state up front that we support the goals of the Executive Order and believe that if it is implemented carefully so that the Labor Department is able to evaluate the responsibility of prime contractors and subcontractors alike as to their legal compliance, it will help achieve the goal of encouraging law-abiding companies of all sizes to be able to compete on a level playing field for government contracts. The Campaign for Quality Construction Groups are the leading specialty construction groups representing the subcontracting component of the construction industry, which comprises nearly 65% of the construction industry. That's by the Bureau of Labor Statistics and Employment Data. It's 20,000 members strong. We are the lion's share of the industry. General contractors, construction managers, and heavy construction firms make up the far lesser share of total employment. It must be stressed for the purposes of this hearing that the vast majority of all the construction work on building projects of significant scope is performed by subcontractors. Also, our member companies have a balanced perspective of federal procurement issues, as we typically perform public works projects as either subcontractors or prime contractors. Our views on these issues are multidimensional. Likewise, our position benefits both small businesses and large business competitors in the federal market. Competitive bidding and project performance are both greatly improved when marginal performers are discouraged from corrupting fair competition in the market, and quality firms can compete without being undercut by non-responsible contractors. Agencies and taxpayers are the beneficiary of these improved conditions. So now just a little about me to lay the groundwork for the summary of our written statement. I've been in the construction industry all my adult life. I started out completing a 5-year federally approved apprenticeship program. That was a long time ago. I started the A&A group over 25 years ago. During that period, I served as the president of the New Jersey Mechanical Contractors. I currently serve as a member of the New Jersey Economic Development Authority. I chair the New Jersey Mechanical Contractors Industry Fund. I serve as a trustee of a union pension and welfare fund, along with chairing the MCAA Legislative Committee. When A&A started with a good deal of hard work and some luck, we graduated to a firm with an annual volume of about $25 million today, with our full-service mechanical contracting, HVA service business, and a separate construction management division. ANA has performed many direct federal as well as state and local public construction jobs on the East Coast at all contracting levels. We are the mechanical prime on a $4 billion World Trade Center project. Our contract is $60 million on that project. We were also the mechanical prime on a Dulles Corridor Metro Rail project and project at the New Jersey Picatinny Arsenal, just to name a few of the direct federal or federal grant projects. We are also agency construction managers for public entities, municipalities, community colleges, New Jersey school projects, county projects, and we also are administering 3 projects for FEMA. So we bring the general contractor construction management perspective to these issues also. We also perform mechanical contracting work for a number of private owners, including Merck, Stepan Chemical, and other pharmaceutical firms, and public agencies, including the New Jersey DPMC, Port Authority New York, New Jersey Transit. We have a broad perspective of accepted industry standards for the strict and comprehensive qualification requirements in the private and public sector, and that should be germane to the committee's deliberation on this issue today. So, our balanced perspective on the executive order is as follows. We support the overall goals of the order: more careful screening of prospective federal prime contractors and subcontractors in order to improve competitive conditions and improve federal construction project performance. Best practices in the private sector prove that more time and effort invested on project screening and planning upfront pays off in improved project performance. Substantially poor legal compliance records may well be the leading indicator of overall poor business practices and increased project nonconformance. In my experience, those who cut corners on the law and safety usually are the ones who are cutting corners on contract requirements. We need a level playing field. If the executive order discourages marginal performers from entering the market, fair competition standards will be improved, and then top quality firms will re-enter the market. Second, the provisions of the executive order seeking to stem worker misclassification are entirely laudable. Rampant misclassification of employees as independent contractors is a scourge of fair competition in construction and leads to other abuse of public laws in both public and the private sector.
Mr. Albanese, if you could, you're over your time, but please continue.
I'm sorry.
Just if you could wrap it up,
Let me wrap it
if
up.
possible.
So to conclude, allow me to respectfully dissent from the title of the hearing. It's neither blacklisting nor adverse to the best interest of legally compliant small businesses or any other businesses. So Co-Chairman Hanna, Hardy, Ranking Members Takai and Adams, and the committee members, thank you for this opportunity. That concludes my remarks, and I look forward to your questions.
Thank you.
Thank you.
Mr. Albanese, I have not heard anyone here disagree with you in terms of the goal. What I have heard, and feel free to correct me, is that this is a very subjective, has the potential to be extremely arbitrary and capricious, that the people who are asked to do this work are neither judges nor juries, that the difficulty associated with outcomes with this is that people are essentially convicted before they're proven innocent, that any disgruntled other contractor, someone in your business, could register a complaint with you about you, have that hanging over your head, and it's up to you to figure out how to get rid of it. So I don't think there's anybody here that argues that people who are bad actors, who are appropriately litigated in that regard, are an issue. But with that, Ms. Stiles, would you like to respond? 'Cause,
I think that's exactly the problem. I mean, there are adequate remedies already, and if people don't think that the remedies are adequate in terms of what Congress decided for the labor laws or how the suspension and debarment system is working, then that's where we should focus on fixing this. If those are the goals, you already have to, many legal remedies under labor laws and the suspension and debarment system to really get it right, to make sure that bad actors aren't participating in the federal procurement
Okay,
system.
so what's driving this?
Well, I assume it's labor interests. I mean, I assume that there are other reasons behind this.
So what would they, I mean, if you feel comfortable saying so, what do you mean by that?
Well, I mean, my presumption is, in part, that that many would prefer that these jobs be done by federal employees. Many would prefer that private companies with labor unions make sure that private companies that don't have labor unions are, not benefited by particular labor laws. I also think it's an effort to have a mechanism. For example, the term compliance agreement. You will not find the term compliance agreement in any statute or regulation except for this proposed rule. If you ask me, it's a way to extort settlements out of companies on a case-by-case basis where the Department of Labor
Well, there's an
wants to-
insidious nature to all of this.
Well, it's certainly, I can't come up with an objective, rational
My word,
explanation.
Mr. Peacock, would you like to respond?
This is a little difficult as a small business, so because first of all, in the AE industry, we are selected based upon. I'm sure you're familiar with the Brooks Act, and we're selected based upon our qualifications. So it doesn't make. We are not going to succeed in a business if we don't have high quality people, if we're mistreating our people. I can't hire good quality people by not paying them a fair wage and by not giving them good benefits and by mistreating them. They're professionals. They're going to go someplace else.
You mentioned that most of this is an anathema to what you would do to run a normal business that's successful, like your business, Ms. Norris.
Absolutely. I have to, when we're selected based upon qualifications, I have to compete with a large number of my fellow firms. And in order to do that, I have to be able to prove that I'm better than they are, that I have more experience, that I'm better qualified, that I have the integrity and the experience.
So you're
to do
okay with the
project.
punishment, you just don't like the lack of due process.
Absolutely.
Ms. Norris?
I fully support what Ms. Stiles and Mr. Peacock have said. We do work hard to make our company a place that people want to come to work. And if I didn't pay a fair wage, if I didn't follow safety requirements, we have a huge safety culture in our company. Every meeting starts with a safety moment. So we do all the things. And again, we don't have any violations right now that we could even talk about. It's that potential of how much it's going to cost us to maintain the records for that, the things that we have to create, because there's nothing in place to track all that. It's just, it doesn't make sense.
Thank you. I'll yield to Ranking Member Takai. Is that right?
Thank you, Mr. Chairman. First, question to Mr. Albanese. There are those that argue that discretion is already given to agency officials to seek out labor law violations before an award of a contract. In your experience, how often are contracting officers asking for this type of information?
In my experience, working, as I said, for private agencies, private companies, contractor pre-qualification is mandated. It's commonly done. New York City has Vendex. The state of New Jersey has DPMC. Port Authority not only has a very strict qualification requirement, but they have an integrity monitor that's on a job. This is common business sense. In other words, it makes good business sense to vet the contractor before he gets the job. It's common in our industry. We do it all the time, and we don't see it as being a burden to any legitimate, fair contractor that's playing by the rules. It's done all the time.
My question, though, is how often are the contracting officers asking for this type of information?
Specific contracting officers, when we did the Dulles job, we didn't have very much vetting at all.
Okay, so
We were just awarded the
right,
contract.
so that's my follow-up then is how effective can this discretion given to contracting officers be if it is rarely utilized to search for violations defined in the executive order?
This executive order will mandate a fair level playing field for everybody that's involved. That's what this will do. And there won't be the gap, hey, give this guy the job, let's not check if he has labor violations, or he doesn't have labor violations, or he violated Davis-Bacon, or he has safety issues that were never investigated.
Okay, so you're advocating that all subcontractors' responsibility determinations be made by the agency. What are your concerns with the prime contractor making these determinations?
Well, if some of the regulations are so hyper-technical on the basis of that, I don't think as a prime contractor, if I was the prime, because we are primes many times, that we want to get into this hyper-technical evaluation. We feel it'd be much better if it would be done by a government agency, a CO, an LCA, to do that process for us. FAR right now does have some regulations that's moving in that direction. That would be a great thing to do.
Okay, thank you. Mr. Peacock, you've addressed concerns regarding the disclosure of your violation to primes, contending that this could harm your business relationships and in some instances eliminate the competitive advantage. However, couldn't some of these concerns be alleviated if the subcontractors went to the Department of Labor for the determination as this guidance allows?
Well, I believe what you're asking is should we be dealing directly with the Department of Labor on these issues as opposed to running it through our competitors? And, you know, one of our concerns is that sharing a lot of our business information with our competitors certainly does put us at a disadvantage. When we have to compete for particularly personnel, highly qualified personnel, there is a shortage of good quality engineers out there. And to keep those people, it's very important for us to treat them fairly and be able to maintain those. And so for us to go, if you want me to deal, I would much rather deal with the Labor Department. My analogy is if most of us have security clearances, I deal with, you know, the Department of, the Security Department for if there's an issue. If I have an employee who has an issue, I deal directly with them. They tell me I have to report to them, and they tell me what I have to do as the facility security officer. It should actually be the same thing. If I have something going on in my company, then I should be dealing directly with the Labor Department and solve that problem and not passing it through a million different people.
Okay, great, thank you. I'll yield back.
Mr. Hardy?
Thank you, Mr. Chairman. Ms. Stiles, do you think it's realistic to expect the labor compliance officers to have the expertise on 14 different federal labor laws and numerous state requirements and laws? Do you think that people have that expertise or could afford that in small business?
I think it's impossible. I mean, we can't even like write my testimony with just me because it takes a government contracts lawyer and a labor lawyer. I don't know how one person or even one set of people can really get a handle on all of those laws and how they operate.
Anybody else care to add to that in any way, shape, or form? Go ahead, Mr. Peacock.
Well, I'd like to comment.
Yes, go ahead.
The issue of complying with this and looking at the pre-qualification forms that I fill out, it would take 10 or 15 minutes of looking at the pre-qualification form to see that there's questions such as, Have you have OSHA violations? Have you have Davis-Bacon violations? Do you have any criminal action or civil action going on? Your financial status, do you owe so much money? These are common basic items that are listed in a pre-qualification. They'd be easy to vet on those specific issues. That would raise the flag, and then you could go into a deeper analysis of it.
Last year, there was over 77,000 pages of new administrative laws placed out, 3,280 some odd new regulations. How many of those do you understand today that have you read, your company read and understand today?
Honestly, probably zero.
Okay. So with these compliance laws, do you believe that you can still keep up with that regular order? I'll move on here. Mr. Peacock, let's talk compliance for a second. They say that what it'll take to implement this is probably only about 8 hours in the FAR Council regulatory analysis. The FAR Council and the DOSL estimate it'll only take 8 hours to figure these rules out. Is that correct?
Well, we currently have 24 IDIQ contracts and estimate at least another 16 single scope contracts. That's 40 contracts, and if I take, sorry, I'm an engineer, if I take 40 and I divide it by 8 hours, that gives me 12 minutes to deal with each one of those contracts, compliance with each one of those contracts. Now, personal opinion is I'm going to, because I'm a subcontractor, I'm going to get an email from, my point of contact of the prime. They're going to say, can you please submit this information to us? Realize that not all these are going to occur at the same time. They're going to occur on the anniversary date of the contract and every 6 months after that, as it's currently proposed, as I understand it. I'm going to get an email. I have to respond to the email. I have to get my administrative people to pull the information, put it together. I have to respond back in an email, and then I'm going to get a telephone call saying, oh, could you give me this in a different format? That's just the way it goes. I can't do all that in 12 minutes. And my estimation is that it's going to take me 2 hours at the minimum to deal with each one of those. That gives me 80 hours on 40 contracts, and I've got to do this twice a year. That 8-hour estimation is way, way underestimated, and it's going to vary for every company, depending upon the number of contracts you have.
Ms. Stiles, another quick question. As a contractor, I've been a prime myself for a number of jobs, and with that, typically, sometimes there's upwards of 30, 40 subs of some kind on major projects. And through that process, should I be required, or how can I follow up with all my subs to make sure that they're in compliance? And any guesstimation of what would happen if I'm awarded a contract and I find out that somebody's all of a sudden become under violation? What is it? Any estimation of what might happen there?
Well, it also requires the prime contractors to become experts on all of these laws and all of these regulations and the mitigating circumstances and what should be done to be compliant by all of the subcontractors that they have. Even small businesses, and many small businesses are prime contractors, they will have large business subcontractors. They will have the largest defense contractors in our country, the Lockheed Martins, the UTCs, the Boeings will be their subcontractors. So you're going to have this small business asking Boeing for all of their labor compliance information, and then that small business has to assess that and has to decide whether they're really compliant or not. I don't know how they do that.
Thank you, Mr. Chairman. I yield back.
Ms. Adams?
Thank you, Mr. Chairman. Ms. Norris, you indicated in your testimony that the disclosures required in the executive order are duplicative as they are collected by different agencies already. However, state violations are not reported, and the contracting officers at the various agencies do not have access to the information at issue. So how would you recommend making these disclosures available to the contracting officer, if not through the method proposed through the guidance?
Well, first of all, we don't know what state laws are going to be required. That has not been spelled out. So that's a little bit difficult to answer. But let me regroup here. Because the proposal process asks for this information, it seems to me that it's already being asked for and that it seems redundant to have a whole executive order to handle a process that's already part of the FAR proposal process. And so I don't know how you would tell the state, other than through the current process where you list what has been a violation on the current proposal process. I'm sorry, that's not part that I am familiar with on the state side.
Ms. Stiles, would you like to comment? I think you also mentioned the duplicative. I believe I heard you say that.
I did mention it, the duplicative piece of it, but you can't say anything about the state piece because it's not, they haven't implemented it yet. But the duplication issue is to avoid de facto debarment of a particular company. So what's happening is that for each contract over $500,000 and each subcontract over $5,000, the contracting officer has to receive all of the information about the violations, including the mitigating circumstances, and evaluate it. And then the guy next door or at the next agency, so maybe it's a contracting officer at DOD, the contracting officer at VA has to look at all of that information again and make their own independent determination as well. And so even if it's two contracting officers sitting next to each other in DOD, they can't talk to each other about it. They have to make their own independent determination. And so it's really duplicative collection of exactly the same information for a prime contract and exactly the same information for subcontractors as well. So there's a reason for it because they want to avoid de facto debarment of contractors and subcontractors, but it's a huge collection of information over and over, the same information over and over and over again.
All right. I have another question. The goal of the executive order is to ensure that the government is not put at risk as a result of awarding contracts to those who do not comply with labor laws. Mr. Albanese, do you know of instances in your business history where marginal performers undercut more responsible bidders and the public agency ended up with a bad project as a result?
Well, the interesting part about that, say, public agency jobs that we're doing. I thought I hit it. Yeah.
Needs to be read.
Okay. The public agency jobs that we do, all the contractors have gone through this vetting process. We know that their financial background supports it. As an example, on the state work, you're giving an amount of money that you can bid up to or have an aggregate of work in place. So my experience is that rarely do we see violations or these violators doing work and getting away with it because they've already been vetted.
Okay. Follow up, Mr. Albanese, isn't it just good business practice to keep track of the information required in the executive order?
It makes absolute perfect business sense to vet a contractor before you're going to give them a $5 million job to make sure, and the list goes on in my pre-qualification list. There's no criminal, there's no civil violations, there's no OSHA violations, that this contractor has paid Davis-Bacon accurately, and he's not skirting the issues. So it makes perfect business sense.
Thank you, sir. Mr. Chair, how you about?
Mr. Rice?
Thank you, Mr. Chairman. I kind of want to step back and look at this from an even bigger picture because I think this particular executive order is just a symptom of a larger problem that this country faces. Here we sit 7 years after the Great Recession, and our economy continues to struggle. We vacillate between 0 or negative growth and 2% growth, where most economists think we should have had a significant snapback by now. And I think one of the big problems that's holding our economy back is this vast mushrooming regulatory burden that all you guys face. So the SBA estimates that the cost of federal regulation on a firm with fewer than 20 employees is $10,585 per employee per year. The president apparently agrees with me. He constantly says we must reduce and streamline regulations on small business. But don't be fooled by what he says. Look at what he actually does. According to a recent study by the Mercatus Center, this administration has issued 120,000 new regulations They claim the prize. They've issued more regulations than any administration since Lyndon Johnson. And not only that, they've done it in 6 years instead of 8. We still have 2 more years to go. So when you look at what he says, we need to reduce regulation, what he actually does, adding all this regulatory burden like this proposed executive order, we shouldn't be surprised when the economy is stifled. Right now, for the first time in 80 years, we've had 5 consecutive years where more businesses are dissolved in America than are formed in America. The first time since the Great Depression. More Americans have left the workforce than in any time in the last 35 years. Home ownership in America is as low as it's been in 50 years. I don't think any of this is coincidental. I think it's all a direct result of the mushrooming regulatory burden that we place on small business. So, I have a question for y'all. You guys are in the regulatory business or in small businesses. Can you name for me, or let me ask you this, Ms. Stiles, do your clients see a streamlined and reduced regulatory burden under this administration?
No, they
Okay,
don't.
I have to go quick. Mr. Peacock?
No, sir, not at all. We're
Okay,
drowning in
thank you.
paperwork.
Thank you, Mr. Norris, Mrs. Norris.
No, we do not.
Mr. Albanese? No, I don't. Okay, thank you. Can Mrs. Stiles, can you name for me one instance where this administration has generated a streamlined or reduced regulatory burden? I'm not talking about a minor thing. I'm talking about any meaningful reduction in cost or time on small business.
Well, I will say that Ms. Rung, who's testifying after me, did issue a memorandum on efficiency on December 14th of last year. So to the extent that that is actually implemented, but I don't see how you implement it consistently with
So
this.
have your clients seen any benefit yet from any streamlined or reduced? I'm talking about material change.
No.
Mr. Peacock?
No.
Mrs. Norris?
No.
Mr. Albanese?
No to that question.
So somehow the rhetoric doesn't match what we're actually doing here. I think that, it goes back to the book, The Death of Common Sense. We are drowning in regulation. If we don't get a hold of this, I think our economy will continue to suffer. I think it bodes very poorly for this next generation coming up in America. When you ask Americans, do you think that your children have a brighter future than you did? And 2/3 of them say no. That bodes badly for this country. And I think this is one of the underlying foundational reasons why Americans feel this way. I yield back.
I want to thank you all for being here today. And for the record, I've got 35 years in the Operating Engineers Union. Support Davis-Bacon. I get it. But it seems to me that it really is a lot of rules and regulations that may even be unconstitutional, since the regulation was not, which we'll get into in the next hearing. But the whole idea of a lack of due process and the subjective nature that is given to a guy whose job it is to manage a project, a contracting officer. My biggest concern is that it's a race to defend and protect the behind of that particular person who has an incentive necessarily to race to the bottom but yet at the same time, if that person isn't thoroughly qualified or in any way not open-minded about the people that have been low bidder, then he has an opportunity to find virtually any reason he likes or she likes to put at risk a company that's been years in business, does great work, may have made a mistake or two in their lives, and we all do, and summarily execute them from a particular job without any formal process. So with that, I want to thank you all for being here. We're going to go to the next panel, and Mr. Harding will be taking the chair. Thank you.
Good morning. We'll start with a quick introduction. I guess better start the meeting. Thank you for being here. I'd just like to start with a quick introduction to our panelists. First, we have Ms. Ann Rung. She is our first witness on the panel. She is the administrator of the Office of Federal Procurement and Policy, Office of Management and Budget. Our second witness is Mr. Leif Solon. He serves as the Senior Labor Compliance Advisor in the Office of the Solicitor at the United States Department of Labor. So with that, Ms. Rung, we'll let you have 5 minutes.
Chairman Hanna, Ranking Member Takai, Chairman Hardy, and Ranking Member Adams, and members of the subcommittees, thank you for the opportunity to appear before you today to discuss the administration's implementation of Executive Order 13673, Fair Pay and Safe Workplaces. My comments today will primarily focus on actions being taken by the Federal Acquisition Regulatory Council, the FAR Council, which I chair as administrator of the Office of Federal Procurement Policy, OFPP. It is important to emphasize at the outset that OFPP and the FAR Council have been working in close partnership with the Department of Labor on rules and guidance to implement this executive order. Our respective organizations are fully committed to implementing the EO in a clear, fair, and effective manner, and have been actively seeking feedback from stakeholders since issuance of the EO more than a year ago. We did this to ensure that we had sufficient information and insight from stakeholders, including small businesses, to achieve these goals. This EO is designed to improve contractor compliance with labor laws in order to increase economy and efficiency in federal contracting. As Section 1 of the EO explains, contractors that consistently adhere to labor laws are more likely to have workplace practices that enhance productivity and deliver goods and services to the federal government in a timely, predictable, and satisfactory fashion. While the vast majority of federal contractors abide by labor laws, studies conducted by the General Accountability Office, the Senate Health, Education, Labor, and Pension Committee, and others suggest that a significant percentage of the most egregious labor violations identified in recent years have been by companies that receive federal contracts. In addition, studies performed by others have found a nexus between companies with labor violations and significant performance problems on government contracts. As explained in the preamble to the proposed FAR rule and in my written statement, we've taken a number of steps in the proposed rule, consistent with direction in the EO, to minimize the implementation burden for contractors and subcontractors, including small businesses. Let me just provide you with a few examples. One, the proposed FAR rule builds on existing processes and principles, including the long-standing requirement that a prospective contractor be a responsible source. Two, many of the contracts performed by small businesses, including contracts valued at $500,000 or less, and subcontracts for commercial off-the-shelf items, are exempt from the proposed FAR rule's disclosure requirements. Further, during listening sessions held by DOL, OMB, and relevant policy councils, stakeholders raised concerns regarding the potential complexity and burden associated with two aspects of the EO in particular. One, provisions addressing disclosure of violations of equivalent state laws, and two, provisions addressing disclosure and evaluation of subcontractor violations. In response to what we learned from these sessions, requirements in the EO addressing the disclosure of violations of equivalent state laws, with the exception of OSHA state plans, will be phased in at a later date. In addition, the FAR Council has developed alternative proposals that seek to address concerns it heard regarding the challenges contractors might face in evaluating violations disclosed by their subcontractors. This includes a possible phase-in of subcontractor disclosure requirements. And the proposed FAR rule has invited public comment on additional or alternative approaches to this issue. Stakeholder feedback has been a very key component in the development of the proposed FAR rule. And currently, the FAR Council is carefully reviewing the many and diverse public comments received in response to the proposed rule, published at the end of May, to determine where additional revisions are needed. In considering comments, the FAR Council seeks to ensure that the final rule is both manageable and impactful in achieving the EO's objective of bringing contractors with significant labor violations into compliance with the law in a timely manner. Without question, implementation of the EO requires the government's policy, operational, and technology officials to address a number of difficult issues head-on. And it's hard work, but work that is critical to the integrity of our procurement system, ensuring economy and efficiency in contracting, and securing the well-being of American workers. Thank you, and I'm happy to answer any questions you may have.
Thank you, Ms. Rung. I'd like to turn the time over to Mr. Solomon. for 5 minutes.
Good morning, Chairman Hardy and Hannah, and Ranking Members Adams and Takai. Thank you for the invitation to appear before your subcommittees to speak about DOL's proposed guidance to implement the Fair Pay and Safe Workplaces Executive Order. For the past year, I have led the efforts at DOL to implement this EO. Although most federal contractors comply with applicable laws and provide high-quality goods and services to the government and taxpayers, a small number of federal contractors have committed a significant number of labor laws in the last decade. Those contractors who invest in their workers' safety and maintain a fair and equitable workplace should not have to compete with contractors who offer lower bids based on savings from skirting labor laws. To address this issue, President Obama signed this EO last year, requiring prospective federal contractors on covered contracts to disclose certain labor law violations and giving agencies guidance on how to consider those labor violations when awarding federal contracts. With this EO, the President pledged to hold accountable federal contractors that put workers' safety, hard-earned wages, and basic workplace rights at risk. The EO builds on the existing procurement system, and changes required by the EO fit into established contracting practices that are familiar to both procurement officials and the contracting community. In addition, DOL will provide support directly to contractors so that they understand their obligations under the EO and can come into compliance with federal labor laws without holding up their proposals in response to specific federal contracting opportunities. Finally, DOL will work with labor compliance advisors across agencies to minimize the amount of information that contractors have to provide and to help ensure efficient, accurate, and consistent decisions across the government. The objective of the EO is to help contractors come into compliance with federal labor laws, not to deny them contracts, and it encourages compliance, not suspension and debarment. The processes and tools envisioned by the EO are designed to identify and help contractors address labor violations and come into compliance before consideration of suspension and debarment. The EO does not in any way alter the suspension or debarment process. However, the expectation is that the processes and tools envisioned by the EO will drive down the need for an agency to consider suspension and debarment and help contractors avoid the consequences of that process. As a result, this EO, once implemented, will offer contractors an opportunity to come into compliance and maintain the privilege of being a federal contractor, unlike the suspension and debarment process, which could exclude them from receiving awards. On May 28th of this year, DOL published proposed guidance. On that same day, the FAR Council also issued proposed regulations integrating the EO's requirements and the provisions of DOL's guidance into the existing procurement rules. DOL's proposed guidance would do several things. First, it would define the terms used in the EO: administrative merits determinations, civil judgments, and arbitrable awards or decisions, and provide guidance on what information related to these determinations must be reported by covered contractors and subcontractors. Second, it would define serious, repeated, willful, and pervasive violations and provide guidance to contracting officers and labor compliance advisors for assessing a contractor's history of labor law compliance and considering mitigating factors, most notably efforts to remediate any reported labor law violations. Third, it would provide guidance on the EO's paycheck transparency provisions. We have received numerous comments and are now reviewing them. Nothing I say today should be taken as a prejudgment of any issue, as I do not want to prejudge the outcome of that process. We are working through the comments to produce a quality guidance document that will better inform federal procurement decisions, provide contracting officers with the necessary information to ensure accurate, efficient, and consistent compliance with labor laws, help contractors meet their legal responsibilities, and remove truly bad actors from federal contract consideration, creating a more level playing field for law-abiding contractors. Most importantly, it will also ensure that hardworking Americans get the fair pay and safe workplaces they deserve. I appreciate the invitation to testify and will be happy to take any questions you may have.
Thank you, Mr. Solomon. And with that, I'll yield myself 5 minutes of time for questioning. With your statement, Mr. Solomon, it sounds like there's quite a bit of challenges out there with people needing to be debarred or suspended. Is that correct? Is that the way I understand your statement? That there's a lot of issues out there that we're having that was cause and effect, that we need to make sure that we are issuing debarments or suspensions?
Well, Mr. Chairman, the executive order is not about suspending and debarment. It is to bring contractors into compliance so we can avoid having to go through, for a contractor, a suspension and debarment process.
That's back to my question. So bring them into compliance. So is there a lot of non-compliance out there?
Well, we have said that the vast majority of contractors do play by the rules and do not violate labor laws. But for the contractors that do violate the labor laws, that is what the executive order is designed to get at.
So when you were at the NLRB as our counsel, how many people did you debar or suspend while you were there?
Well, the NLRB has no debarment or suspension process.
Department of Labor? Okay. How many did you refer, I guess, is the question.
Well, the NLRB, like the various enforcement agencies at DOL, have a jurisdiction that is beyond federal contractors. So it does not come up in an investigation at the NLRB as to whether the employer involved is a federal contractor or not.
Okay, Ms. Stiles testified that the proposed rule was a chance for agencies to extort settlements from small businesses. What's your opinion on that?
I don't think that is a fair statement. We want that what this executive order does is looking for the most egregious violations, a pattern of a basic disregard of labor laws. The executive order is clear that not one violation of a labor law is going to lead to any problem in the contracting process.
Thank you. Ms. Rung, the construction contractors commonly state that they have usually, if they're in the general, they have more than 7 tiers of subcontractors. The EEO and proposals, as a prime, would I need copies and records of all 7 tiers?
Yeah, I appreciate your question, and it was extremely helpful feedback this morning from a lot of the small businesses. As we've been out meeting with small businesses to talk about this and other issues, the one issue they have raised is the flow down piece of this, how primes will sort of implement this piece of it to track and measure performance by their subcontractors. And in response to that, we've done a number of things and put a number of proposals in this rule. Just to mention one, for example, one alternative in which we're seeking feedback on would allow subcontractors to take their information on labor violations and provide it directly to Department of Labor and work with Department of Labor to assess those violations. So you would essentially be taking the prime contractor out of the role of sorting through that information and evaluating the records provided to them.
Does that individual, that prime, need to make sure that they monitor those performances also?
So the prime contractor has always been responsible for ensuring that their subcontractors are responsible subcontractors, so that role would continue. So they've always had to ensure that their subcontractors are performing.
Let's bring into OSHA rules. I myself have an OSHA 40. I'm on the site continually when I was working. Have other officers that have their OSHA 40 and make sure that things are complied with. It's typically the subcontractor that you sometimes have a challenge with on that, and it puts me at risk. I can run that individual off, but does that put me in violation when it's somebody else's employee and we're doing everything we can to keep on track? Is that a violation?
Thank you for the question, and certainly if my colleague from DOL wants to jump in at any point, he can, but we're really focused on the most egregious violations. So I think the GAO report from 2010 that cited several examples give you a good indication of what we mean by serious violations. So when they refer to, example, a food company that has over 100 OSHA violations that ultimately result in an employee being killed, that's an example of what we're talking about.
Can I stop you there? My time is running out, but does that violation, we're talking about violations, and what happens? It gets stuck, as you've heard, in the process. It's a violation. I might be bidding on another project, and as long as that's hanging over my head, I'm guilty until proven innocent.
Well, I think there's a couple things. One, the CEO has a number of provisions designed to ensure that we're not slowing down the process. So one of the key parts of this is to encourage companies to work with Department of Labor very early in the process, well before award, to help bring these companies into compliance.
Thank you. My time's expired, Ms. Adams. I recognize Ms. Adams for 5 minutes.
Thank you, Mr. Chair. Mr. Wong, some subcontractors have expressed concern that prime contractors do not have the requisite knowledge in labor law to make an informed decision as to their responsibility. Isn't there enough regulatory discretion in the executive order and in the Federal Acquisition Regulatory Council itself to justify having the agency contracting officer and the labor compliance advisor review all covered prime contractors and subcontractors in the initial responsibility review process?
Thanks for the question. So it's been a longstanding tenet of the federal procurement system that the prime contractors are responsible for the performance and ensuring that their subcontractors are responsible companies. The LCAs and the contracting officer are responsible for making that determination of business integrity and ethics for the primes. And that's the way historically it has worked. In this case, as I just explained, we very much appreciate and have heard from a lot of small businesses the concern about primes tracking the subcontracting piece of this. And as such, we've laid out a number of alternatives in this proposed rule for which we seek feedback, including this notion that subcontractors could go directly to Department of Labor to work with them on the reporting piece, and to have Department of Labor evaluate that information.
Thank you. One of the main concerns voiced by those opposed to the executive order is that they fear that due to de facto debarments will occur if contracting officers are relying on the same recommendation when making a responsibility determination. So what mechanisms are in place to ensure that this does not happen?
So we're very much focused on bringing companies into compliance and not excluding them. And so we're doing a number of things to ensure that we can achieve that goal. And one of them is setting up a process within Department of Labor to have them work with the companies very early in the process, well before the bidding, to help bring them into compliance. We want to create a system where information can be shared among all the agencies, so we're ensuring that consistent decisions are being made, and we're also limiting burden to the extent possible for our contractors in terms of reporting many times.
Okay. There's been much criticism as to the inclusion of administrative merit determinations in the executive order. Mr. Solomon, can you explain why the decision was made to include these decisions in the disclosure requirements?
Thank you for the question. I think it's important to start with what administrative merit determinations are not. And they are not charges that are filed by workers with the enforcement agencies saying that, alleging that there have been violations of the federal labor laws. Once the charge is filed, there is a full and thorough investigation by a neutral government fact finder. They take into account all evidence presented by both the workers and by the company. And in my experience, there are a significant number of these charges that are found to be without merit in all of these enforcement agencies. So what an administrative merits determination is after this complete, thorough investigation, the agency concludes that there has been a violation of the labor law, and that what we say in the proposed guidance, and we have a lot of comments on this portion of the guidance, but the guidance says that the notice or complaint that is served on the employer by the enforcement agency is, in fact, the administrative merits determination. And I would also add that, there is a significant percentage of these administrative merits determination that in effect become final determinations because they're either settled or if they are litigated by the employer, which the employer has every right to do, the government has a very, very high win rate of those.
Okay, I'm just about out of time, Mr. Chairman. I yield back.
He yields back. I'd like to recognize Chairman Hanna for 5 minutes.
Thank you. If you know who all these violators are, and they've committed all these egregious problems, which, I'm sure they're out there, why not just go after them? Why create a burden for companies who may have hundreds of subcontractors, and the process doesn't work the way you described it, I don't think, that we don't know, a contractor doesn't know who he's going to hire until the day he may bid the job. So how is he supposed to screen all this stuff and all these people, use their number, which may be low or whatever, and then rely on that number, put his business at risk, and hope that you guys go along? And the other problem I have with this is, what does egregious mean and what does significant mean? I mean, those are subjective words that any contract officer or any judge or jury or person can use in any way they like. So I wonder if you really have if you have a notion of how you're going to navigate that with some degree of earnest fairness that produces the outcome you want, when apparently you already know who these people are based on if it's egregious and significant, then I guess I could find out who those people are. But our worry is, my worry, is that this will trickle downhill depending on who decides what that means and what some outside force, an unhappy other contractor, second bidder, labor person, union or non-union. So what do you say to that?
So let me, perhaps I'll address the question about the information that's already out there, and then my colleague can jump in on some of the definitions. But the challenge for us is that the information is not always available to us. So the current penalty triggers for reporting violations into the performance system may be higher than the individual labor violations. And secondly, a contractor is not required to enter information into the federal awardee integrity and performance system unless it's done more than $10 million in business. And third, not all violations are accessible to us. And I think as GAO has emphasized that our contracting officers, for whatever reasons, are not using the information to make accurate responsibility determinations. So what we're trying to do here is ensure that our contracting officers have timely and complete and detailed information to make these responsibility determinations, which are already required to do.
This contractor shows up. He or she is the company is low bidder. They base their assumptions on all these different places from who knows how many companies. And then you enter the picture and say this person or that person isn't qualified. How do you reconcile that in the real world?
I think, what we heard from some of the panelists this morning is that we're creating a level playing field by ensuring that only those contractors that play by the rules are competing in the federal marketplace.
How could it possibly be level if they don't know in advance who those people are? And is it really a contractor's problem that you don't know when apparently the information is out there?
The information is not always available, and it's not always out there, and it's not available in a timely fashion, and it's not always available in a complete fashion. And I think the evidence has been borne out by the GAO report. So the outcomes are showing that we are awarding taxpayer dollars to companies that commit serious labor violations. And our goal here is to simply ensure that we protect taxpayer dollars.
To answer part of your question, I mean, the intent behind the guidance and the intent behind the creation of labor compliance advisors throughout the government is to to provide a mechanism for uniform and consistent decision-making across the government. I think there is an understanding that contracting officers do not necessarily have the knowledge base to be able to make decisions over a company's labor law compliance.
As though you got a lot of work ahead of you to implement this in a way that's in any way reasonable or fair or provides the outcome that you want.
Well, you know, the most compelling part of the GAO report to me were the examples of the kind of companies that are receiving federal taxpayer dollars, even though they've committed serious violations, including, you know, OSHA cited company for over 100 health and safety violations. And after an employee was fatally asphyxiated after falling into a pit containing poultry.
Sure, I get that, but I mean, my
That's
time's
the
expired,
kind of
but shouldn't,
violations we're
why
talking
is
about.
that company even out there? I mean, if you know who they are, and you do today, why didn't you know yesterday? Why isn't that someplace in the public domain? I swear that it must be. My time's expired, but thank you. I apologize for cutting you off.
Gentleman's time has expired. I'd like to recognize Mr. Takai for, the Chairman Takai for 5 minutes.
Thank you, Chairman. You know, I am concerned about some of the comments made by the previous panel about the effects that this executive order may have on the federal marketplace. So, Ambassador Rung, what do you say about those? What do you say about those arguments made by them about primes and subcontractors exiting the federal marketplace if they have to comply with this executive order?
Thank you for the question. I think when, you know, the Federal Awardee Performance and Information Integrity System, I know that's quite a name, FAPIS, was introduced per statute in 2010, we heard similar concerns that by making transparent performance information and violations, we would be keeping good companies out of the marketplace or, you know, discouraging primes from engaging with subcontractors. And in the end, we did not see an impact on the type of companies entering our federal marketplace. However, I do agree with you that we need to do more to ensure that we are continuing to bring good companies into the marketplace. And I think there's a number of reasons why they're not entering the marketplace today, many of which I outlined back in a December 4th, 2014 memo where I talked about ways to drive greater economy and efficiency in the federal marketplace, and not the least of which is I think it's incredibly challenging for our contractors to navigate through 3,200 separate procurement units across the federal marketplace with very little collaboration and sharing of information.
Yeah, I appreciate our efforts to bring more companies into the federal marketplace. I think the question is that we currently have companies in the federal marketplace that we might be pushing out. So my other question is in regards to providing prime contractors with the opportunity to work with contracting officers and the LCAs on disclosures. So will subcontractors have the opportunity to access the LCAs regarding the disclosures?
If I could just address your one point about this driving out companies already in the marketplace, particularly small businesses, we are taking a number of steps to really help minimize the burden on companies and in particular small businesses. A couple examples are we're phasing in parts of this rule over time to give companies a chance to acclimate themselves to this new rule. And secondly, you know, we have outlined some alternatives that I've discussed earlier that I think will help minimize that. The reporting requirements of subs to primes. We're improving the IT infrastructure. Most importantly, and I think this really can't be emphasized strongly enough, we are limiting this executive order to contract awards over $500,000. And when you start with a base of several 100,000 small businesses in the federal marketplace, and you take away from that companies that are doing business under the 500,000 threshold for which this EO would not even apply. And then you take from that the vast amount of companies that are already complying with labor laws. You're talking about a very small fraction of companies that would have any disclosure requirements whatsoever.
But you're talking about 500,000 for the prime or 500,000 for every sub?
The 500,000 limit applies to both primes and subs.
Okay, so
And
that
for
could be problematic for subs.
No, this is an advantage to them because what we're saying in the executive order is if you are awarded a contract under $500,000 at both the prime or sub level, this executive order does not apply to you. And for the vast majority of small business transactions, they fall under the $500,000 award.
Okay, well, if you can get us information regarding that, that'll be helpful. Okay, so my question is, my next question is, would a subcontractor who is deemed non-responsible by a prime have the same process of redress that a prime has if it's ruled non-responsible by the contracting officer? In other words, does the subprime contractor have redress in this particular case?
So the historically, the performance of the subcontractor has been the responsibility of the prime. So it would be the prime that would ensure, that there's satisfactory performance and/or there's business integrity and ethics. And that is a relationship between the two of them that the sub would work through with its prime.
Okay, but if they're being labeled as non-responsible for a prime, by a prime, is there recourse at your level? Is there anything they can do? I have 8 seconds.
I'm not aware of that.
All right.
But I'm happy to look into it and see if I can get you a more complete answer.
Okay, thank you. Thank you, Mr. Chairman.
The gentleman yields back. I'd like to recognize Mr. Rice for 5 minutes.
Thank you, Mr. Chairman. This is all very interesting to me. You heard me talking earlier, I think, about the fact that for the last 5 years, the regulatory burden has mushroomed under the federal government. You also heard me tell that the SBA, which is the federal government, the SBA says that for a firm under 20 employees, the federal regulatory burden costs $10,585 per employee per year. So let me ask you, with respect to small businesses that have to comply with this new law, is this going to be free for them? Is it going to cost them money?
So we very much recognize that there is a cost to this.
So the answer is
proposed
yes.
rule.
Mr. Solomon, you agree with that? Yes. Okay. We've had more small businesses closing than we have being formed in this country in the last 5 years. First time that happened since the Great Depression. I think that has a lot to do with this mushrooming regulatory burden. You think this new rule is going to ease their regulatory burden? It's going to pile more on their heads?
This is designed to create a more level playing field for our small businesses.
I'll take that as it's going to add more. Mr. Solomon, what do you think?
I agree with my colleague.
Okay, good. You were saying that you're trying to protect taxpayer dollars. I mean, any single transaction that occurs in commerce, I guess we could look at every single transaction from a bank deposit to a withdrawal and say there may be a taxpayer dollar involved, so we should get involved in that. Should the government be involved in every single transaction?
So it's been a longstanding tenet of the federal procurement system that when we spend taxpayer dollars, we're doing so while we're also ensuring that the contractor receiving those taxpayer dollars are a responsible source, and that means that they're—
Mrs. Rung, is this the only regulation that you oversee?
I oversee the federal acquisition regulations, so there's several.
What have you done? How long have you been with this?
I was confirmed a year ago this month.
Okay, what have you done that has a material reduction in small business cost or time in your regulatory authority?
So there have been a number of successful steps forward in the small business arena in the past year. One was creating set-asides for small businesses on task and delivery orders. One was working into senior management performance plans, small business goals. And we've also, worked on a number of other provisions.
How much time or money do you think you've saved small businesses as a result of these?
Look, I think in the end, by doing business with companies that comply with labor laws and all laws, we ensure greater economy and efficiency in federal procurement, and that's long been understood.
So the answer would be none? Is that what you're saying?
The answer is following the intent of this executive order is to ensure that we promote economy and efficiency by ensuring that we do business with companies that comply with laws.
Mr. Solomon, you were at the National Labor Relations Board I think, in fact, you were the guy who issued the opinion that Boeing couldn't move their Dreamliner production line from Washington to South Carolina. Is that right?
I issued the complaint. It was not as you state. The theory of the case was not as you state. It was not about the opening of South Carolina.
Do you think the government should be able to say where businesses can open their production lines? You think the federal government should be able to dictate where a business can open its production line?
The basis of the complaint was not saying where Boeing could locate its business. The theory of the complaint was that they would have built this line in Seattle as they have done all other lines, except for the fact that their employees unionized and would go on strike.
All right, so if you believe that the government has that level of intrusive authority into a business, do you not think that this new proposed rule could very easily be used for political purposes to grant government contracts to people who are favored by the administration? It seems to me like this rule is rife with potential for corruption.
With all due respect, Congressman, I think you will find nothing in the guidance or the FAR rule that would lead to that conclusion.
All right. I appreciate very much your time, and I yield back.
Gentleman yields back. Thank you for being here. Thank you for your participation. I just would like to state a couple of things that, 57% of the associated builders and contractors say that under this rule, they will no longer participate on government contracts. That's huge. Last year, small business received over $57 billion of non-commercial item contracts. This is nearly 60% of the prime contract dollars spent with small businesses. At a time when the federal contractors are already struggling, I wish I could say that I'm leaving here today convinced that the administration heard the concerns being expressed by our small businesses. Witnesses and going on to respond in an appropriate manner. So I hope you really consider what has been said here today and think about it. I thank you for being here. I appreciate your testimony. I know it's hard to come here and stand before people sometimes, and unfortunately this happens. But hope you reconsider your thought process, at least at my standpoint, and thank you for being here.
Thank you.
It's okay. Well,